All right, good morning. I'm Judge Chungan. We are here on People of the City of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James Kazicki. I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not support the same theory.
Mr. Crane, sir, you do have the right to have a court-appointed attorney.
Okay, pause right there. Did you catch what just happened? Crane's court-appointed attorney basically tapped out, saying he can't represent him because they don't support the same theory of law. Lee, translation? Crane is deep into sovereign citizen ideology, where regular legal principles don't apply, and his lawyer knows it's a losing battle. This is a rare moment. You almost never see a defense attorney openly say, "We don't speak the same legal language." Now, here's the thing. You do have the constitutional right to represent yourself, but courts strongly discourage it, especially when the defendant is armed with YouTube scripts instead of actual statutes. What do you think? Should attorneys be forced to represent clients with these kinds of arguments? Or should they be allowed to?
You do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
You have assistance, but you don't want it.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you have.
I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Kazicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pre-trial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir. So in this matter,
let's unpack this for a second. Crane is facing a misdemeanor for obstructing an officer, maximum 90 days in jail, $500 in fines, and up to 2 years probation. That's not life-changing, but it's still serious. And on top of that, he's got civil infractions for no proof of insurance and no registration. Those carry fines, not jail time. But here's the kicker. Instead of focusing on fighting the charges, Crane is more interested in debating the court's jurisdiction. This is classic sovereign citizen playbook. Ignore the actual charges and argue that the system itself doesn't apply. It rarely works, but it always makes for a show. If you were in Crane's shoes, would you focus on fighting the obstruction charge? or go all in on challenging the court's authority? Be honest. What's your move?
You are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until the jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf, and you could testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example, prosecutor could never tell the jury that, oh, you must be guilty because you didn't testify. We don't allow that, sir. The people have to prove you're guilty, your guilt beyond a reasonable doubt. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So you're going to meet with an attorney here in the court. You write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9 a.m. All right. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, you can't be sent to jail for these. They're simply not criminal offenses. All right. You'll be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, you've stood mute. I'm going to note you're requesting appointed counsel. I'm also noting for the record, you had spoken with Mr. Kazicki and he's not able to represent you any further. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
I'll explain it again. You come back on July 16th in court for a pre-trial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part, But what I don't
Okay.
understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to,
And here it is, the moment we were waiting for. Crane pulls out his sovereign citizen script and demands $1,400 per court appearance. This isn't just a stunt. Many sovereign citizens actually believe they're entitled to compensation because they view court as a breach of contract with the state. Judges usually let them finish talking, then politely move on, just like we saw here. Notice how the judge didn't even flinch. He's heard it all before. But think about it. If every defendant billed the court for their time, the legal system would collapse overnight. Still, Crane's confidence is almost entertaining. He says it with the conviction of someone who truly believes he'll get paid. What about you? If the court had to pay you to show up, would you be charging $1,400 or more?
going to be able to discuss that at a later date. This was just to advise you of the charges formally
Okay.
lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Okay, sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
So let's recap. Today's hearing introduced us to Randall Crane, a sovereign citizen defendant who lost his attorney before the case even started, stood mute at arraignment, and then demanded $1,400 per court date as part of his personal contract. Judge Chungan remained professional, sticking to the book, and released Crane on personal bond until his next hearing. But here's the real takeaway. Sovereign citizen tactics almost never hold up in court, yet defendants continue using them, often making their situations worse. This case is far from over, and Crane will be back in front of the judge, likely with even more scripted arguments. What do you think? Does the court handle sovereign citizens the right way? Or should judges come down harder to shut this down quickly? Let us know in the comments. And if you found this breakdown as wild as we did, make sure to hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom commentary. Trust me, you won't want to miss what happens next.